Hello, Michigan Realtors, and welcome back to From the Mailbag. I'm Becky Berke, and today's Q&A will tackle some frequent questions we receive on the Seller Disclosure Act. Let's dive into some questions from the mailbag. Question 1. I have a seller client who is the trustee of a property owned by her parents' trust. She currently resides in the property. Is she exempt from filling out the statutory seller disclosure statement? No, she is not exempt. The Seller Disclosure Act does include a list of exemptions that will excuse a seller from filling out the disclosure form. One of those exemptions includes transfers by a non-occupant fiduciary in the administration of a trust. But this exemption does not apply to our scenario because the trustee here is currently living in the home. Only non-occupant fiduciaries are exempt. Question 2. The owner of a home I'm listing has inherited the home from his father. He does not live in the home, but the legal title is in his name. Does he need to complete a seller's disclosure statement? Yes, he needs to complete the disclosure statement. It's true that a property owned by an estate is exempt under the Seller Disclosure Act, so long as the personal representative does not live in the home. But once the property has been distributed from the estate to the heir, it's no longer exempt. Question 3. I'm listing a residential property for a seller client who has relocated to another state. I told him that I would fill out the seller's disclosure statement on his behalf since he's out of town. Is that permissible? No. Listing agents should never fill out the seller disclosure statement on behalf of their seller client. If an error is later discovered, the agent may find themselves in a position where both the buyer and the seller are pointing fingers at them. Question 4. The house I've listed was the scene of a homicide. Is that something that I have to disclose to prospective buyers? No, at least not voluntarily. Listing agents and their sellers are not required to disclose to prospective buyers that a property was the scene of a murder or some other gruesome crime. Now, if the buyer specifically asks if anything of that nature has ever occurred on the property, then you have to answer that question honestly. But as a rule, listing agents in Michigan are not obligated to volunteer that information absent a specific inquiry. Well, that wraps up another installment of From the Mailbag. For more information on this topic, be sure to check out its companion Letter of the Law video, which is linked in the description. If you have any questions or suggestions for new topics, please send those to the email listed below. Based on input from you, as well as our Michigan Realtors Legal Hotline, our legal team will continue to work on content to help you as a realtor. As always, thank you for watching, and we'll see you next time.